Welcome to the Litigation Psychology Podcast, brought to you by Courtroom Sciences. Here's part 2 of my interview with trucking plaintiff attorney Joe Freed. Now, sticking with this theme of differences between, plaintiff and defense attorneys, there's difference between plaintiff attorneys. Now, I'm dying to get your input on this.
You're about to get me in trouble, aren't you, Bill? You're about to get me in trouble.
I am trying to get you in trouble. I'm not going to mention any names. I did in my outline, but I'm not going to mention his name. But you have some pretty popular plaintiff attorneys out there. You know who they are. They're very vocal about their absolute disdain for the insurance industry. They're very, very active, and they don't hide this stuff. They're very, very public with it, essentially calling the insurance industry, the evil empires. It's all their fault. And then the infamous Morgan & Morgan email that came out a few months ago with the Florida tort reform, essentially saying we're really going to stick it to the insurance companies, coming right from the Morgan & Morgan email. And they've created this, again, this kind of like where we started this conversation, this absolute hatred. And I think that's turned into certain plaintiff attorneys that behave in certain ways, particularly in discovery, where they send the threatening emails. They're borderline unprofessional, if not unethical, during depositions, as far as some of the tactics that they pull during depositions. And they come out and essentially send an email saying, I want your entire policy, and if you don't give it to me by Friday, I'm not negotiating. We're going right to trial. I don't see you doing those things. I see a lot of other people doing those things. What do you think about those tactics? Because I think those are actually growing in popularity, and I see more and more of them from the plaintiffs' bar.
Well, I mean, as you might imagine, if I thought that was the right way to practice law, I would do it.
You do it. Yeah.
So I don't do it. And honestly, I cringe when I see some of the things that I see. But I also think that I don't know if it's growing or not. I'm trying to be a voice in the other direction because I don't think it's good. Talk about, killing the goose that laid the golden egg, it's kind of a silly thing. Look, I mean, I've had my own cases where people on the defense, certain companies, certain defense lawyers, certain defense, where the tactics were what I'll call a scorched earth kind of a tactic. The way I've chosen to deal with that is to say, if that's the way you want to go, I'm not going to fight you on it. I am going to take it to a jury. And some people say, try the lie. I'd say, try the game. If you want my recipe for a huge result, if I can show the game that's being played, now the case is about something that's more important than the case. It's about the jury can be empowered to not disendorse the game, if that's a word, but to say that that's not the way we're going to practice. That's not the way we're going to do it in our jurisdiction, ... And so I think it's terribly unfortunate, the level of the lack of professionalism that sometimes I see. But I also see, I have to say, I also see some fantastic, the lawyers who I think are the best plaintiffs lawyers. They're not doing that. They're people who you would have a reasonable conversation with on the other side. They have a different bend and a different point of view than people on the defense, a lot of them, and that's fine. I mean, we're all entitled to our point of view, but where it becomes venomous, I just disagree with that. I think the courts, unfortunately, have not helped us in these regards, because if I were a judge, and I spent 20 years as a part-time judge, and I don't want to be a full-time judge, for this very reason. I mean, the infighting is just ridiculous. I was in a case not long ago down in Florida, and I got brought in to try the case, and the sides were at each other's throats so much. We're in federal court. I went down my first appearance in the case, and literally these lawyers on both sides, plaintiffs lawyers, defense lawyers, I mean, it's like a melee in the freaking federal court, and
Yeah.
they're in the middle of the well of the court, yelling at each other, spit coming out of their mouth. I mean, pointing fingers. And I was leaning back and looking at this, and the judge finally leaned over and said, "Mr. Freed, are you enjoying the show?" And I said, "No, sir, I'm horrified. Honestly,
Yeah.
I'm in courts all over the country. I've never seen conduct like this." And he said, "Yeah, welcome to my world." And
Wow.
yeah, in the back of my mind, I thought, it's your world because you're tolerating it.
Yes.
I mean, I hate to say it, but you don't have to tolerate it. And I think, if courts, whatever side, and this is to say, if whoever's on my side deserves to get hit, then by God, so be it. And I would welcome it, and vice versa. But if the court started coming down and saying, you know what, we're going to require decorum, we're going to require professionalism. Whoever, if you want to bitch about something, come in and bitch about it. If you're right, you're going to get the sanction you're looking for, and if you're wrong, you're going to get your ass kicked for overreaching. And let's start putting this thing back together again. I don't think it's too late for our system. And I don't think that while I do think that there are fringes that do the stuff you're talking about, and I know this is a really long, meandering response, but I think the vast majority of lawyers, this is not happening with. And then there's the ones you and I can name, and and we can probably name them on both sides.
Yeah. Oh yeah. I agree.
They thrive on that fight. They got to have that bitterness. And when I always look at them, and I teach my lawyers this, I always say, first of all, if someone's a jerk to you, doesn't give you the right to be a jerk. I tell my people.
Yeah.
I use the a-hole word, but I don't. I won't here. But just because you're treated some way doesn't give you the right. Doesn't give you the right to tick for tat kind of a thing. But I think at the end of the day, what I always do is I look at those people and say, gosh, something's going on in their life to keep them that way.
Mm-hmm.
And I'm glad that that's not going on in my life. So that's the way I deal with it. But I'm not sure I answered your question, but I sure meandered a lot.
You certainly did. But yeah, it's something that's out there. But I know that you're very appreciated by many for handling things the way that you do. I got a couple more.
Sometimes, Bill, though, you talk about weakness. Some people look at what I do and say, well, that's weak.
Yeah.
Joe's backing down. I don't see it that way at all. And I would, people say, well, you've done well. Imagine how much better you would have done if you would have done the blah, blah, blah. And I totally disagree. But because of the way that I choose to practice, not only do I get good results for my clients, but I'm at a recent event, one of the telematics companies, one of the video companies, got up. I was speaking. It was actually at a defense program, and one of the telematics, it was the lytics person. The lytics person got up and said, my number one customer is in the audience today, in terms of, if you define customer as the person who's responsible for more lytics trucks having the lytics system in it than any of my customers, is in the audience, and he probably doesn't even know he is. And then called me out, and I had no idea. But I look at every single case as an opportunity at the end, not only to have done something good for the client, but to do something good for the motor carrier and their drivers. And if I see a safety issue, I try to require the correction of that safety issue as part of the resolution. So, there's over 100,000 trucks out on the road now that have dash cams that wouldn't, or that at least didn't, before we were involved in litigation with them. There's a bunch of companies out there who are using automatic emergency braking now that didn't before because of that. But anyway, I think this is by far the right way to do things, because when you're just about venom, it never ends. It never ends.
Totally agree. Totally agree. Couple more questions for you, then I'm going to let you go. And again, this has been a fascinating discussion. I want to get a little bit more specific here. Deposition testimony, particularly when you're deposing, say, a corporate representative, a safety director, even a driver, but I'm thinking more of particularly the corporate people. And the witness has been instructed to do something called pivoting. You've heard of this?
Yeah. I think I'm a victim of pivoting.
Yeah. So in other words, so
yes,
you
but,
point,
yes,
yeah.
man, yes, and, or no, but, or
yeah, exactly. So it's the yeah, but, no, because, no, because, no, because. And so what these witnesses are being told to do, this is a big issue with me. I rarely lose my cool, but when I start talking about this, my blood boils, is that some witnesses are told, so when the plaintiff attorney points out a fact in the case, for example, a fact in this case is that the driver was going 10 miles per hour over the speed limit. Isn't that true? Right? The answer is yes. I mean, that's a factual question. But a lot of defense attorneys are instructing their witnesses to say, yeah, but, and then pivot to a defense theme. Which I think is a terrible, just horrible mistake, because I think it's a very evasive maneuver. I think it's a political debate maneuver, because that's where that came from. And I don't think it's really strong testimony, particularly when it's something factual. When that happens to you, when a witness does that to you, when you're just trying to get them to admit to a fundamental fact in the case, they don't like the fact, so they go, yeah, but, and they start talking about something else. How do you reel them back in? And I would assume that no witness has a chance to win the deposition against a sophisticated veteran questioner like you.
Well, I don't know. You're giving me a lot of credit that I'm not sure I deserve, because
You deserve
what I tell people on my side is I lose if I get mad.
Yeah.
So I give all my power away when I get mad. And so what I've also trained myself is that when I start to get mad because I have somebody playing some kind of a game on the other side, what I've learned to do is see if I can make that into a game for the case. Because if I can bottle up that anger that I'm starting to feel, and I can deliver that frustration, let's just call it frustration, if I can deliver that frustration to the trier of fact, then I'm gonna at the end of the day, I'm gonna be the one smiling. So I agree with you that I think you should. I think defendants, just like plaintiffs, I mean, if you got a bad fact, you lead with it and say, here it is, and this is my bad fact. Yeah. I mean, and
own it, right?
No guarding. There's no. I mean, you can't you can't do the guarding thing around the fact, and you can't say, well, everybody does it. You can't, you can't diminish. You go, yes, and we shouldn't have been going 10 miles an hour over the speed limit. There's more to the case than that, but I mean, that's for another question. That's not what you're asking me. So when you say, how do I reel them in? It's going to depend on the circumstance. First of all, don't assume I want to reel them in.
Yeah.
Sometimes I want them to keep fighting with me.
And why? Tell me why, because I know the answer, but I want to hear this.
At the end of the day, if I'm fighting and I've managed my emotional state, so I'm not coming from anger, then who looks like the idiot? Thank you. Okay, so and people think they're winning that exchange when in fact they're just digging a little deeper, the hole for themselves, because they can't just say, you can't just say you were speeding. No, I mean, it was speeding, but blah, 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 blah. I can't just say, I shouldn't have had my cruise control on in the rain. I mean, some of these things are so endemic to safe or not safe driving, depending on how you're looking at it. Just own the damn thing. But if I really want to reel somebody in, I mean, what I've come to do is I stop and I write the question on a piece of paper, and I put a box and I write yes, and I put a box and I say no, and I say, let me mark this as Exhibit 5. Can you please check the box? And they want to fight about, sometimes then it turns into the lawyer fighting with me, which is fine also. This is not a check the box deposition, Mr. Freed. This is
Yeah.
so your lawyer doesn't want you to check the box. So if you were going to check the box, I'll check it for you. Which one should it be? I mean, you're not going to win that exchange. At the end of the day, I think that there's lots of ways to talk about controlling the witness, but you also really do need to, I mean, what I would tell any plaintiff's lawyer, and I would tell the defense lawyer too, it's about, at that point, when those things start to happen, it's very much about how do you show up. I mean, so are you going to allow the situation to make you angry and you become less effective if that happens? I think every time you become less effective.
100%.
And so, but I don't mind people arguing with me.
Of course not.
my sometimes, maybe I shouldn't admit it out loud, but sometimes that's my goal. I'd much rather you fight with me about speeding.
Exactly.
Than just to own that you're speeding. It's for the same way that if you're refusing to, I'm looking for the things that are, quote, indefensible that you're defending.
Yeah, exactly.
That's what I call the game, right?
Yeah.
If you're looking, because now you're giving me a trial narrative that's different than whether or not somebody was speeding. That's not even the narrative anymore.
Yeah.
The narrative is that you can't admit anything, and now
Facts.
who are you more afraid of, jury, or who not afraid? That's wrong. Who are you more willing to smack?
Yeah.
Or who needs to be smacked? I mean, if someone comes in and says, yeah, my driver was going 10 over and shouldn't have been, what would be the best pivot would be to then be able to say, and you know what we learned from that? We learned that we really need to encourage our drivers in a way that they weren't going to do that. So we've implemented policies and procedures and some changes in now you've changed the energy of the room.
Yeah.
As opposed to trying to defend making it okay, go the other way. And I know this isn't the question, but the same is true, by the way, if you're trying to get a case resolved. When you come into a room on the plaintiff side and you say, hey, we are sorry, you know what that sounds like to us? It sounds like we're sorry that you got caught and now have to pay a shit ton of money. That's a technical legal
exactly
term. Okay. What would be better is if you came in and you said, hey, I want you to know we looked at this and we didn't like what we saw. And whatever happens here today, we want you to know we've made some changes. We've made them company-wide, and we've already done them. We're not doing it if you settle today. We've already made these changes. Now you're going to change the energy in my room away from anger and anyway, I'm going beyond your question.
Yeah, but it's an interesting topic. It's one I'm very passionate about because I don't think witnesses should argue with fact. I don't think witnesses should try to win the deposition. I don't think they should be defensive or evasive. I think they should own the facts. And if there's blame going around in questions and they disagree with that, they can disagree. But I think it'd be the same on your end. If there was surveillance video of your client, that is claiming various injuries, and there's video of him playing basketball with his kids in his driveway. Yep. And the defense attorney's doing a deposition, right?
It never happens to me, Bill. That would never happen to me.
Yeah, never, right? But if that was a factual issue, I would assume you would want your client to say, yes, I was playing basketball with my kids, and not try to say, yeah, but I was feeling good that day, and you don't understand, and try to like weasel your way out of that when it's right there in black and white. And the more you argue, like you said, you just keep digging this hole and it looks terrible.
Look, I agree. Obviously we what you're hitting on is credibility. At the end of the day, what you're hitting on is credibility. And you can ask, I believe that the party with the credibility at the end wins almost invariably. Okay. There's probably some exceptions to that. But if we accept that as a premise, then you can actually look at everything that's happening in the courtroom and saying, what's the net effect on credibility from this?
Yeah.
And are we increasing ours, decreasing theirs, or are we treading water? And so what's the most credible thing to do if you've done something inappropriate? Just say I did something inappropriate. And you have to trust. Here's the thing that's hard for people to do. You have to trust that doing that without guarding actually improve, you get a bigger increase to your credibility than whatever your perceived downtick is for the bad fact.
Exactly.
So I actually need, this is going to sound crazy and people are going to call me out on it, but I'll own it for you.
Thank you.
I need bad facts in my case.
Of course.
I need them because it gives me the opportunity. I'm not going to say that I don't try to get rid of them if I can, but when the ones that I can't, I own them so big. I lead with them.
Yeah.
I want to be, I call it being shockingly credible. I
Yeah.
want to get up. I mean, I know that in the world, I'm a plaintiff's lawyer. I'm coming in asking for a lot of money. I'm that guy. So I have zero credibility. If there's a meter, I'm below zero, starting out. And I feel like I have to, how do I start to be perceived as something other than that? What starts in jury selection and probably before, starts in the elevator before jury selection, right?
Yeah.
But it actually starts in the way you build your case, and are you going to build it credibly and dot. But then throughout the whole process, it's just about if I can, in jury selection, when there's the monster juror, I used to dread. Now I smile, go, hallelujah. I get an opportunity to have a guy call me greedy, have a guy call me, my case sucks. I mean, there's never been a case that's ever been good. Great. I mean, those questions now they're music to my ears.
Yeah.
Because they give me an opportunity. You're a greedy lawyer. Yeah, sometimes I am a greedy lawyer. You're right. And I mean, whatever it is. Anyway, I'm rambling again.
Well, that's okay. I gotta wrap up. Joe, thank you so much for coming on. This is one of 165 podcast episodes. This may be my favorite. I really thank you so much.
I bet you say that to all your guests, but that's all right.
I do. See, I'm not going to pivot away from that. I'm going to openly admit I say that to all my guests. No, actually, I don't. I think this has been fantastic. I would love to have you back on because a couple of things that we said, particularly kind of the jury selection part of this, I think that would be a fantastic episode to really get into the weeds on that. And I would love your thoughts, and particularly on various venues, state court versus federal court. I think that would be a fascinating topic as well.
Well, I'd love to anytime. You just let me know, and if I can fit it in my schedule. I think you and I share one thing. I know that I'm doing exactly what I'm supposed to be doing in the world, and my sense is that you believe that about what you're doing as well.
I do.
And there's nothing I'd rather be doing than what I'm doing, and I sense that that's true for you as well. So it's nice to talk to a true professional who's trying to look outside the normal places to try to understand this game that we're playing a little better and from a little different perspective than the stodgy way that we've all done it in the past. So I think while we tend to be on opposite sides, I don't know that that's really true. At the end of the day,
that's an amazing point.
My hope is that all of our work ends up leaving this place a little better than we found it. So I appreciate you having me, Bill.
Thank you so much. Joe Fried, Atlanta, Georgia. And this is the Litigation Psychology Podcast. Thank you for participating in this episode. We will see you next time.